California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparable Analysis, 2007 to 2008 edition. Chapter 5, Joinder of Parties and Claims. Subpart A, Joinder of Parties and Claims generally. 1. Permissive joinder of parties. Permissive joinder of plaintiffs. Code of Civil Procedure Section 378 permits joinder of plaintiffs if they assert any right to relief arising out of the same transaction, occurrence, or series of transactions or occurrences. And if any question of law or fact common to all these persons will arise in the action. The courts liberally construe the statutory standard so as to permit joinder of plaintiffs. See Anaya v. Superior Court of 1984, where numerous employees of oil company permitted to join in one lawsuit seeking damages for exposure to toxic chemicals over the course of 20 years. State Farm Fire and Casualty Company v. Superior Court in 1996, where a group of insured homeowners whose homes were destroyed by an earthquake were properly joined as plaintiffs. Permissive joinder of defendants. Permissive joinder of defendants is proper where the complaint asserts against them any right to relief arising out of the same transaction, occurrence, or series of transactions or occurrences, and if any question of law or fact common to all defendants will arise in the action. CCP 379, see Farmers Insurance Exchange v. Adams, 1985, joinder of 300 homeowners as defendants in action by plaintiff insurance company to declare plaintiff not liable for storm damage held inappropriate because claims did not arise from the same transaction or occurrence. There are important advantages to joining all co-defendants in one lawsuit, where each defendant blames another defendant for the plaintiff's injuries. The typical example is a tort case where each defendant denies negligence but argues that the plaintiff's injuries were caused by another defendant's negligence. If the plaintiff pursues separate actions against each defendant, there is a risk that the plaintiff will recover nothing, even though the jury finds that her injuries were caused by some defendant's negligence. How so? What are the other advantages of joining several co-defendants into one action? What are the disadvantages? Federal Rule 20A compared. The broad permissive joinder test of CCP 378 and 379 is essentially the same as that of Rule 20A of the Federal Rule of Civil Procedures. See California Law Revision Commission comments of 1971 amendments. Now for Part 2, permissive joinder of claims. I guess I'll say Section 2 of Subpart 1. Code of Civil Procedure, Section 427.10 provides that a plaintiff who alleges a cause of action against one or more defendants may unite with such cause any other causes which he has against any such defendants. This provision effectively eliminates misjoinder of claims as a defense so long as joinder of parties is proper. See Landau v. Salam, California, 1971. The unlimited joinder of claims authorized by CCP 427.10 is the same as that of Rule 18A of the Federal Rules of Civil Procedure. So may unite with such cause any other causes which he has against any such defendants. That's the permissive joinder of claims. We were earlier talking about the joinder of parties. Section 3 of Subpart 1. Actually, Subpart A. Subpart A, number 3, compulsory joinder of parties. Code of Civil Procedure, Section 389, which conforms substantially to Rule 19 of the Federal Rules of Civil Procedure, sets forth the criteria for compulsory joinder of parties. Section 389 requires joinder of any person who is subject to service of process and whose joinder will not deprive the court of subject matter jurisdiction and who meets one of the criteria stated in Section 389A. In such circumstances, the trial court should not dismiss but should order joinder of a missing person. See Conrad v. Unemployment Insurance Appeals Board of 1975. If joinder is not possible, then the trial court must consider factors such as those contained in Section 389B, to determine whether, as an exercise of equitable discretion, the action should proceed with the existing parties or should be dismissed. See Delta Keeper versus Oakdale Irrigation District, 2001. In a writ proceeding challenging an environmental impact report for a project involving a joint district water purchase agreement, trial court erred in dismissing the writ petition for failure to join all of the water purchasers as indispensable parties because the non-joint parties' interests were adequately represented by the existing parties, and there was no adequate remedy if the action is dismissed as the statute of limitations had run for joining more parties. That's People ex rel. Lundgren versus Community Development Agency in 1997. The trial court abused its discretion in dismissing a complaint filed by the Attorney General against the city's Community Redevelopment Agency to set aside a contract between the agency and the American Indian tribe under which the agency would transfer real property to the tribe for development of a gaming casino where the tribe could not be joined because of its sovereign immunity. Only if the trial court determines dismissal appropriate only if the trial court determines dismissal appropriate is the absent person regarded as indispensable. Safar Bay Inc. versus San Diego Unified Court District in 1996, affirming the dismissal of the mandate proceeding brought by an environmental organization challenging the adequacy of an environmental impact report for a marine project where the landowner whose land had to be acquired to complete the project was an indispensable party who could not be joined because a statutory 30-day limitation period for joining the landowner had expired. So now we're at subpart B, titled Cross Complaints. Cross complaints generally is the first section. Under subpart B, the California cross complaint is a multi-purpose pleading device which permits the party defending against a cause of action to assert her own affirmative cause of action against an opposing party, a co-party, or some other person not already a party to the action. CCP 428.10 through 428.80. The California cross complaint serves the same functions as a similar counterclaim, cross-claim, and third-party interpleader in federal courts. See Rules 13 and 14 of the Federal Rules of Civil Procedure. The California legislature opted for the one-term-fits-all approach in 1971 when it eliminated technical limitations of prior methods of countersuits and replaced them with a single form of pleading. So rather than saying cross-claim, counterclaim, we're referring to them as cross, not counter. So counterclaims were abolished and deemed cross complaints at that time, per 428.80. The cross complaint is one of the four types of pleadings allowed in civil actions, Section 422.10 of CCP, and is the only pleading other than a complaint that can demand affirmative relief. See CCP 431.30c. Affirmative relief cannot be claimed in an answer. A cross complaint must be filed and served as a separate document and must comply with the same form and content rules applicable to a complaint. See CCP 425.10, 428.40 through 428.60. A cross complaint must, within 30 days after service, be responded to in the same manner as the original complaint. Dismissal of the underlying complaint does not constitute dismissal of the cross complaint. Seeing that occurred, and that is covered in CCP 581. Compulsory cross complaints is part 2. Keep going. Code of Civil Procedure 426.10 and 426.30 set forth a general preclusion rules for failure to plead a compulsory cross complaint. Section 426.30a states, except as otherwise provided by statute, if a party against whom the complaint has been filed and served fails to allege in a cross complaint any related cause of action which, at the time of serving his answer to the complaint, he has against the plaintiff, such party may not thereafter in an other action assert against the plaintiff the same cause of action not pled. Which is somewhat unfair. Because I've already got this deadline answer. And, like, her attorney isn't a mind reader. So, over the course, some things come out that might actually sound like a complaint that you maybe didn't get from your initial consultation. But anyway, Section 426.10 defines complaint to mean complaint or cross-complaint. 426.10b defines plaintiff to mean a person who files a complaint or a cross-complaint. And Section 426.10c then provides related cause of action means the cause of action which arises out of the same transaction, occurrences, or series of transactions or occurrences as the cause of action which the plaintiff alleges in his complaint. Section 426.10c utilizes the same type of transactional standard in defining compulsory cross-complaint as is utilized in Rule 13a of the Federal Rules of Civil Procedure in defining compulsory counterclaim. See Curie Medical Specialties v. Newell Bowen of 1982. Both the federal and California courts apply the expansive logical relationship test when interpreting the transactional standard. Cross-complaints, equitable indemnity, and good faith settlements. Cross-complaints and equitable indemnity. California follows the tort rule of comparative negligence, under which an injured individual's recovery is proportionally diminished rather than completely eliminated when the injured individual is partially responsible for the injury. Lee v. Yellow Cab in 1975, subject to some important statutory exceptions such as those expressed in Civil Code Section 1431 through 1431.5. California also follows the doctrine of joint and several liability, whereby each tortfeasor whose negligence is the proximate cause of an indivisible injury remains individually liable for all compensable damages attributed to that injury. Summers v. Tice of 1948. This doctrine recognizes that the wronged party may sue one or all of such concurrent or joint tortfeasors to obtain recovery for his injuries, but that the tortfeasors should be left to determine the allocation of loss among themselves. In apportioning liability among concurrent tortfeasors, California permits partial equitable indemnity, under which liability among multiple tortfeasors is apportioned on a comparative fault basis. American Motorcycle Association v. Superior Court. This is incredibly relevant to what I do today. Like, seriously, from there down is global settlement, which is the topic of the week. A typical use of the cross-complaint joinder device is to assert a claim for partial equitable indemnity against an existing co-defendant or against a new third-party defendant. This is your cross-complaint joinder device. To assert a claim for partial equitable indemnity against an existing co-defendant or against a new third-party defendant. This use permits a court to resolve all potential liability issues between plaintiffs and defendants and among defendants in one lawsuit. For example, assume that plaintiff sues defendants A, B, and C for injuries caused by defendants' concurrent negligence. The defendants file cross-complaints for equitable indemnity against each other. The jury awards $100,000 in damages and allocates fault as follows: plaintiff 10%, defendant A 10%, defendant B 30%, and defendant C 50%. Based on comparative negligence, the plaintiff is entitled to recover 90% from the defendant. Under the doctrine of joint and several liability, the plaintiff can recover the entire 90 from one or more of the defendants. If defendant A pays the entire 90 to plaintiff, how much can defendant A then recover from B based on defendant A's cross-complaint for partial equitable indemnity and from defendant C? Good faith settlement. When a settlement is entered into between the plaintiff and one of several joint tortfeasors prior to trial and is determined by the court to be a good faith settlement within the meaning of CCP 877 to 877.6, that settlement bars any other joint feasor from further claims against the settling tortfeasor for equitable comparative indemnity. joint and several liability. And one thing I'm really going to point out here is that they have to file cross complaints. The defendants even though the plaintiff brought the action against all three, the defendants still have to assert their cross complaint. And that's something that happens in civil practice, but doesn't happen in workers' comp that I'm doing right now. So don't forget it when you go back into civil litigation. So, also, in the cases where the doctrine of joint and several liability applies, the plaintiff's recovery from the non-settling tortfeasor is reduced by the amount of good faith settlement. So, that's good to know. The court will declare that a settlement was made in good faith if after following the hearing procedures set forth in CCP 877.6 and applying the relevant standards set forth in Tech Built Inc. v. Woodward, Clyde, and Associates of 1985, it concludes the amount of the settlement is within the reasonable range of the settling tortfeasor's proportional share of comparative liability for the plaintiff's injuries. Tech Built Supra, in other words, a defendant's settlement figure must not be grossly disproportionate to what a reasonable person at the time of the settlement would estimate the settling defendant's liability to be. Why require a settling defendant to settle in the ballpark of estimated liability in order to gain immunity from comparative indemnity? The effect of a good faith settlement. Following hypothetical demonstrates the effect of a good faith settlement. Assume plaintiff sues 3 joint tortfeasors for injuries caused by their alleged negligence and that the doctrine of joint and several liability applies. Plaintiff settles with defendant A for $50,000 prior to trial, and the settlement is determined to be in good faith within the meaning of CCP 877.6. Defendants file cross complaints for equitable indemnity against each other. Following a trial, the jury awards plaintiff $250,000, allocating as follows: defendant A 10, defendant B 30, and defendant C 60. How much is plaintiff entitled to recover from the non-settling defendants? If defendant B pays plaintiff the entire amount, how much is B entitled to recover from defendant A? From defendant C, how much is defendant A entitled to recover from defendant B? Fair Responsibility Act. The voter-approved Fair Responsibility Act of 1986, Prop 51, which all the voters know what Prop 51 is when they're voting on it. Civil Code Section 1431 through 1431.5 modifies the common law rule of joint and several liability by making each defendant's liability for non-economic damages several and for not joint in comparative fault cases. Each defendant shall be liable only for the amount of non-economic damages allocated to that defendant in direct proportion to that defendant's percentage of fault. Civil Code 1431.2a. Non-economic damages are defined in Part B of that section to mean objectively verifiable monetary losses such as medical expenses and loss of earnings. Economic damages to mean subjective, non-monetary losses such as pain, suffering, loss of consortium, and injury to reputation. The Fair Responsibility Act complicates the apportionment calculations in good faith settlement situations. Alright, so this is another highly relevant. This is all very highly relevant to my job. So, for example, the complication of the apportionment calculations in good faith settlement situations occurs in Espinoza versus Mechonga of 1982, applying the following formula for calculating offsets from a good faith settlement. The portion of the settlement which may be set off from a judgment of economic damages is determined by application of the percentage of the economic damages awarded in relation to the total award of damages. Hackett versus John Crane. Okay, one more paragraph. In 2002, applying the Espinoza formula in a wrongful death action. Try your hand at answering the questions in the following simple hypothetical. Assume plaintiff sues defendants A, B, and C for personal injuries caused by defendants' alleged joint negligence. Plaintiff settles with defendant A for $300,000 before trial. The jury renders a verdict for plaintiff against all defendants for a total of $1 million in economic damages and another $1 million non-economic damages. The special verdict allocates fault as follows: defendant A 60% responsible, B 30%, C 10%. How much is plaintiff entitled to recover from defendant B and from defendant C? The next section of the chapter is titled Intervention, and we'll get into that with the Bus Stop versus Superior Court of 1977.